Hearing in the matter of Argentum Exploration Limited and Republic of South Africa.
Mr. Smith. Mr. Hofmeyr, we'll take a short break for the stenographer at about 10 minutes to 12.
My Lord, I'm grateful. My Lord, as my Lords are aware, I appear with my learned friend, Mr. Wadsworth KC and Mrs. Wells, on behalf of the Republic of South Africa. My learned friend, Mr. Hofmeyr KC, appears for Argentum, together with Ms. Larty and Mr. Miles. This is our appeal against the decision of the Court of Appeal, dismissing in turn our appeal against the judgment and order of Sir Nigel Tier, sitting as the Admiralty Judge. The judgment of Sir Nigel is at tab 7.6 of the core, 207, and is summarised at paragraph 15 of the Statement of Facts and Issues, which is at tab 4 of the core bundle. His order dismissing our application is at tab 7.4 of the bundle. The judgment of the Court of Appeal is at core tab 7.3 and is summarised at paragraphs 22 to 25 of the Statement of Facts and Issues.
I'm working on a purely electronic bundle which doesn't have tabs.
I will refer to the pages then.
If you could try and give me as many of the electronic page numbers as you can, I would be extremely grateful.
My Lord, so just to recap then, the judgments of Sir Nigel Tier is at core page 207. The Statement of Facts and Issues, page 15, summarising that, is at page 33. His order dismissing our application is at page 201. The judgment of the Court of Appeal is at page 149 and is summarised at paragraphs 22 to 25 of the Statement of Facts and Issues.
We've probably found it by now, since you imagine we've read them beforehand.
My Lord, I agree. As my Lords will be aware, the appeal concerns an Admiralty claim in rem and our application challenging the jurisdiction of the court on the grounds that the Republic of South Africa is entitled to immunity under Section 1 of the State Immunity Act 1978, alternatively Article 25 of the Salvage Convention. On the hearing in the Court of Appeal, various issues were raised by the court relating to REC and the provisions of the Merchant Shipping Act concerning the receiver of REC. Those are set out at paragraph 17 of the Statement of Facts and Issues at page 35, but they don't concern my Lords today. The conclusions of the Court of Appeal are set out at paragraph 21 of the Statement of Facts, and nothing turns on those in this appeal. The roadmap for our submissions, I hope helpfully, is as follows. I will deal firstly and relatively briefly with the facts giving rise to the claim in rem and the appeal. And I will then outline, in summary, the reasons why we say the majority of the Court of Appeal erred, and outline the issues that arise on the appeal. I will then deal with and consider the nature of Argentum's claim being a claim in rem and the significance of it being a claim in rem in relation to the claim for state immunity. So that essentially is paragraphs 1 to 34 of our written case. Mr. Wordsworth KC will then deal with the Brussels Convention, customary international law, and the issues arising out of the Human Rights Act, which is essentially paragraphs 55 to 74 of our written case, and also 113 to 120. And I will then conclude by drawing the strands of all those submissions together and setting out what we say is the correct construction of section 10.4a and our case as to the conclusions which the court should reach. So essentially paragraphs 35 to 54 and 75 to 112 of our written case. Turning, if I can, to the facts, these are all summarised and very little in dispute, paragraphs 1 to 8 of the Statement of Facts and Issues, pages 29 to 30 of the core. The case concerns, as the title of the in rem action states, 2,364 silver bars, which were purchased by then the Union of South Africa in 1942 to be used at the South African Mint to mint coins. And although, in accordance with the judge's findings of fact, some of that silver may have been intended to mint non-union coinage, for which the mint would have charged a cost and made a modest profit, it is now common ground that the intention of the silver was sovereign, because the greater part of the consignment was going to be used to mint union coinage. So the silver was, we say, purchased for a predominantly sovereign purpose. The silver was shipped on board Talawa pursuant to a contract of carriage which was in fact entered into by the government of India on behalf of the Union of South Africa, although the Union was therefore a party to the contract of carriage with the owners or possibly the charterers of Talawa. And that contract of carriage, although the documents aren't available and weren't available indeed before the judge at first instance, was contained in or summarised in a bill of lading in the usual way. And it is our submission that the contract of carriage was made clearly for the purpose of carrying the silver from India to South Africa to be used at the South African Mint, and that therefore the purpose of the contract of carriage was sovereign, to enable the silver to get to the Mint and be used for the minting of coin. Talawa sailed on the 17th of November 1942 and was sunk by enemy action on the 23rd of November 1942. 281 passengers and crew sadly lost their lives. The silver was not insured, and so title remained with the Union of South Africa and in due course passed to the Republic of South Africa, and there is no issue now but that the Republic is, and at all material times has been, the owners of the silver. In 2017, the silver was recovered from the seabed between the 29th of January and the 23rd of June. The salvage operation was performed by a specialist salvage vessel named the Seabed Worker, and Argentum claims to be entitled to salvage in relation to that operation. We dispute that, or will in due course dispute that if relevant, but for present purpose it must be assumed in Argentum's favour that they are the salvor entitled to the salvage award. And having been recovered and after being wet stored for a period of time, the silver was transshipped onto another vessel, the Pacific Ascari, and that was within the South African contiguous zone, and it was then carried to Southampton, where it arrived on the 2nd of October 2017. After that, Argentum declared the silver, as they were obliged to the receiver of wreck pursuant to Section 236 of the Merchant Shipping Act 1995. All of this, and again I think this is common ground, without the knowledge or consent of the government, the owner of the silver. The present action in rem against the silver was commenced by a claim form dated the 1st of October 2019. So it was just within the limitation period of 2 years provided for in the Salvage Convention, Article 23, if the salvage operation terminated when the silver was landed in Southampton, but well outside the limitation period if the silver was at a place of safety earlier than that. And that limitation issue will be live before the court should the claim to immunity fail in due course. The claim form was not at that stage served either on the cargo, on the rees, or on the government, but on the 3rd of March 2020, the government filed acknowledgement of service pursuant to Rule 61.3 of the Civil Procedure Rules, which permits a party with an interest in the property to acknowledge service even though the claim form has not in fact been served. And we acknowledge service purely for the purposes of challenging jurisdiction pursuant to 58.7 of the Civil Procedure Rules and Part 11. Our application was issued on the 3rd of March 2020. And our case, as I've outlined, is that we are entitled to immunity under Section 1 of the Act and or Section Article 25 of the Convention. Argentum's contention is the exception to immunity in Section 10.4a of the State Immunity Act is engaged. Section 10.4, in fact, deals with claims in rem and in personam. And if I could invite my lords very briefly, I'm sure we've looked at it already, but to put it into context, to look at Section 10 in the authorities bundle. The Act begins at page 1697. And the Act commences at Section 1 with the grant of general immunity from jurisdiction 1.1, a state is immune from the jurisdiction of the courts of the United Kingdom, except as provided in the following provisions of this Act. And we'll be looking at various provisions during the course of the hearing, but the particular provision that my Lords is concerned with is section 10.4 A and B at page 1701. This is in the section headed ships used for commercial purposes, but it applies equally to cargo. And section 10.4 provides, subsection A state is not immune as respects an action in rem against a cargo belonging to that state if both the cargo and the ship carrying it were, at the time when the cause of action arose, in use or intended for use for commercial purposes. And then in section 10.4b, state is not immune as respects an action in personam for enforcing a claim in connection with such a cargo if the ship carrying it was then in use for intended for use as aforesaid. So it is 10.4a that Argentum relies on in the circumstances of this case. So, having outlined the relevant facts as I indicated to my Lords a moment ago, I will now highlight the issues that arise on the appeal and the principal reasons why we say the majority and Sir Nigel erred in concluding that the state of South Africa was entitled to immunity. In particular, the key issue is that both Sir Nigel Tier and the majority of the Court of Appeal held that in 1942 the silver was in use for commercial purposes, such that section 10.4a, which we were just looking at, was engaged. And the conclusion that the silver was in use for commercial purposes was variously explained on a number of bases. Sir Nigel Tier, paragraph 163 of his judgment, at page 236 of the core, looked at the fact that it had been sold under an FOB contract and was shipped on board pursuant to a contract of carriage contained in a bill of lading, and concluded that assisted him in concluding that the silver was in use for commercial purposes because both of those contracts were commercial contracts.
Is that 163, did you say?
Paragraph 163,
yes, thank you.
Page 236. Lord Justice Popperwell, at paragraph 90, page 175, also looked at the fact that the government had made arrangements for the silver to be put on board the vessel and carried by sea, so commercial arrangements. And he said it was that which gave, that use which gave the cargo its status as being commercial for the purposes of the maritime claim for salvage. Lord Justice Popperwell also considered that context was everything and that the silver was in motion over the sea when the vessel sank, and that the government as cargo owner had created those circumstances for its cargo. And that's paragraph 92 at page 175.
Sorry, page?
175.
Thank you.
Lady Justice Andrews, paragraph 117, page 181, was influenced by the fact, relatedly to Lord Justice Popperwell, that the silver was on board the vessel for the purposes of being transported pursuant to two related commercial contracts, the contract of sale and the contract of carriage. She therefore concluded that the silver was there to serve the purpose of those commercial contracts. And later in her judgment, Lady Justice Andrews, at paragraph 126, page 184 of the core, referred to the fact that the silver was being used to fulfill or perform obligations under the transactions which the government had engaged in, and that those transactions were otherwise than in the exercise of sovereign authority.
The first of those references to Lady Justice Andrews again was paragraph
117, page 181.
Thank you very much.
The second, 126, page 184. Lady Justice Elizabeth Leng, by contrast, considered at paragraph 142, page 188, that as a matter of ordinary language, the silver, which at all relevant times was simply sitting in the hold of the ship, was not being used by the government for any purpose, whether commercial or otherwise. In her view, it was simply being carried. It was the subject of commercial arrangements for its carriage, but that was not the relevant inquiry under section 10.4a. The inquiry under section 10.4a is directed at the use or intended use by the government of the cargo. not the nature of the arrangements by which the cargo was carried. And that since the intended use of the ship, silver was predominantly sovereign, the government was entitled to immunity. And we submit that the approach of Sir Nigel Tier and the majority of the Court of Appeal to the construction of Section 10.4a was flawed for a number of reasons. I'll summarise them now and we'll go on to develop them in due course. Firstly, it fails to give the words "in use" in Section 10.4a their ordinary and natural meaning, and effectively ignores the words "or intended for use." Secondly, the approach of the majority is in effect to remove the careful distinction drawn in Section 10.4 between the threshold for immunity in respect of claims in rem, which is Section 10.4a, and the threshold for immunity in respect of claims in personam, which is Section 10.4b, because 10.4a in rem claims has the added requirement to consider the use or intended use of the cargo. Thirdly, in our submission, the approach of the majority is inconsistent with the scope of immunity in respect of state-owned property generally, as suggested by other provisions of the State Immunity Act, and in particular Sections 6 and 13. And I'll be dealing with those points in due course. Fourthly, the approach of the majority is inconsistent with Article 3 of the Brussels Convention, to which Section 10.4 is intended to give effect. And fifthly, it is not required by the restrictive theory of state immunity and customary international law. And therefore, our construction does not engage a requirement to read down the provisions of Section 10.4. Both of those issues to be dealt with by Mr. Wordsworth in due course. And so it is against that background that the 5 issues on the appeal arise. Firstly, in holding that the silver was in use for commercial purposes in 1942, did the majority err in its interpretation and application of the phrase "in use" or "intended for use" for commercial purposes? Secondly, did the majority of the Court of Appeal err in holding that the intended use in 1942 was not relevant to the application of Section 10.4.2, 10.4b(a)? Thirdly, did the Court of Appeal err in interpreting the phrase "at the time the cause of action arose" by reference to the time when the maritime circumstances which made the silver a recognised subject matter of salvage arose?
Is that still a live issue?
It's live in the sense that we still submit that the correct conclusion is that the cause of action arises in 2017. It doesn't affect the outcome in the sense that we accept that even if one looks at this position in 2017, the facts in 1942 are relevant as evidence in relation to what one treats as the use or intended use in 2017. So it's live in the limited sense that it remains our submission that cause of action could not arise in 1942, not least because Argentum didn't exist in 1942. But in practical terms, it doesn't affect the outcome of the appeal.
Thank you.
Fourthly, if applying the ordinary rules of construction to Section 10.4a, the government is entitled to immunity, must Section 10.4a be read down pursuant to Section 3 of the Human Rights Act? And finally, the conclusion from those 4 other issues is the government entitled to immunity from this claim in rem.
And if you're right, what then follows? If you're right that you have immunity, what then follows?
The original application, which was to set aside the claim form in rem, succeeds. The claim form in rem is set aside. My Lords will have seen from the statement of facts and issues that subsequently, in fact, I think about 2 days before the original hearing in front of Sir Nigel, Argentum have issued a claim form in personam. They obtained permission to serve that out of the jurisdiction. It took some considerable time for that service to be effected through diplomatic channels. By way of update, since the statement of facts and issues was agreed between the parties, that claim form has now been served on my clients in the Republic of South Africa, and indeed we have acknowledged service of the in personam claim form. So issues will arise in relation to the in personam claim form, but they will be different issues. Well, some will overlap, but there will be others that are different. So by way of example, there will be a challenge to the question of whether Argentum was able properly to put itself within the Part 6 gateways to obtain permission to serve out. But there will also be the same issues that would have arisen on the in-rem claim form, the time bar issue, and whether Argentum is a salvor entitled to salvage in respect to the operations that were carried out by seabed worker.
But no immunity issues in relation to the in personam proceedings? Because
of the effects of Section 10(4)(b) and the fact that it is now, it wasn't originally, but is now common ground that the vessel, the ship, was in use for commercial purposes at the relevant time.
Thank you.
So, my Lords, having looked at the facts and the principal reasons why we submit the Court of Appeal erred, I will, if I may, just give the Court, although the Court will have seen this from our written case, an overview of our submissions in relation to the approach to the Court of Appeal. And our claim to immunity turns on whether both the cargo and the ship carrying it were, at the time when the cause of action arose, in use or intended for use for commercial purposes. We've looked at that already, but it's important to note that unless Argentum can establish, and we do submit, and I'm not sure that this is in dispute, but we do submit the burden is on Argentum in this respect, can establish that the silver was in use or intended for use for commercial purposes when it was being carried on Talawa, then the Republic is entitled to immunity, subject only to the question of whether Section 10(4) then needs to be read down. There is no issue between the parties as to the meaning of the words commercial purpose, but it may nonetheless assist in the overall construction of the section in the context of the Act to look briefly, if we can, at Section 17, which is in the Authorities Bundle at page 1707. And by Section 17, subsection 1, headed Interpretation of Part 1, in this part of the Act, and the second definition, commercial purposes means purposes of such transactions or activities as are mentioned in Section 3, subsection 3 above. And if one then turns back to Section 3, subsection 3, at page 1698, for the purposes of Section 3, subsection 3, a commercial transaction means a contract for the supply of goods or services, any loan or other transaction for the provision of finance and various other provisions, and C, any other transaction or activity, whether of a commercial, industrial, financial, professional, or other similar character, into which a state enters or in which it engages otherwise in the exercise of sovereign authority. So those are the definitions in Section 3, which are then incorporated into Section 17. But it's of note that Section 3 is concerned with proceedings relating to a commercial transaction. And it's common ground that Section 3 is not engaged on the facts of this case. Argentum only relies on Section 10(4). So this is not a claim. These are not proceedings relating to a commercial transaction. And that's an important point that we say needs to be borne in consideration when looking at the construction that Argentum applied to Section 10(4)(a). So there being no dispute about the meaning of commercial purposes or commercial transaction, the appeal, as I've said, turns on the meaning of the words arose, but actually doesn't turn on the meaning of those words because for the reasons I've mentioned already, and then intended or intended for use as they apply to the cargo.
I mean, that's what it all comes down to for these 2 days, isn't it? What those few words mean, literally.
And possibly even...
And there's two alternatives, and one of them's right and the other isn't.
Indeed, my Lord, and I don't think, well, there is no dispute as a matter of fact. The cargo was intended for use for predominantly sovereign purposes, and that is sufficient. So actually probably comes down to the words in use. And it is our submission that in 2017 and indeed 1942, the silver was not in use at all. It is common ground, as I've said, that the ship was in 1942 in use for commercial purposes and therefore falls to be treated as being in use for commercial purposes in 2017. And as regards the ship, she was also in use for commercial purposes for the purposes of Section 10(4)(b), so in personam jurisdiction. And when one considers the context of the State Immunity Act, against which Section 10(4) has to be construed in our submission, the most obvious and significant point of context appears within Section 10(4) itself, the distinction between the treatment of claims in rem and claims in personam. As we saw when I took my lords to Section 10(4), Section 10(4)(b) provides that the state will not be immune in respect of in personam proceedings for enforcing a claim in relation to state-owned cargo if, and this is the only requirement, the ship carrying it was intended for use or in use for commercial purposes.
When's the ship going to be intended for use? When is the ship going to be intended for use?
I think one of the examples given is the possibility, for example, of a new build ship at delivery that hasn't yet commenced any kind of service. So she's being delivered to the buyer with the intention of using her for commercial purposes.
But then there won't be a cargo.
Then there won't be a cargo, but I think my lord's question related purely to the ship at this stage.
Well, I expect it related to 4B.
I was dealing with 4B, and
Yeah.
my lord, yes, I think the question related to 4B, and the reason you refer to intended use or use is to recognise that although a ship is usually going to be in use, she may occasionally be in an intended use. Another
But
example.
it's talking about a ship carrying a cargo being in use or intended use.
My lord, I see the point, and so it's perhaps not such a good example. So if the ship is carrying the cargo, it's
rather a point in your favour, I would have thought, because if it doesn't have any application, then that might be a mirror image of the converse.
Well, our submission in due course will be that the words in use or intended for use, as they apply to both the ship and the cargo, are simply there to recognise that in various different circumstances there might be a use or an intended use, and not because one has to be able to tick every single box. They're questions that require a yes-no answer, and if you answer yes, intended for use for commercial purposes, or yes, in use for commercial purposes, there is no immunity. But if one answers no to all of the questions, then there's nothing unusual in that. It simply means that there is immunity because the commercial nexus has not been established. And in our submission, it's important to reflect on the fact that, as is common ground, as Lord Justice Popplewell recorded at paragraph 77 of his judgment, page 117 of the court bundle, that the use or intended use of the ship is the use to which the cargo owner, the state cargo owner, is putting the ship in terms of section 10(4)(a). So we're considering the ship owner's use of the ship, and we're not considering, as was postulated at one stage, possibly the salvor's use of the ship in performing salvage services to her. We're considering the use by the cargo owner. So it follows from that in our submission that to ask whether the vessel was in use for commercial purposes is in essence simply another way of asking whether the state's cargo was being carried pursuant to a commercial contract. Because if one is looking at the use by the cargo owner and the contract of carriage is on commercial terms, it inevitably follows that the ship is in use for commercial purposes. And what that means is that if for the purposes of section 10(4)(a) it is relevant or decisive to look at whether the cargo is being carried on commercial terms, that removes altogether the difference between 10(4)(a) and 10(4)(b). And that as a headline level is an important reason why we submit that Sir Nigel Tier and the majority of the Court of Appeal went wrong. They held that the silver was in use for commercial purposes because it was being carried pursuant to a commercial contract. We can see that, and it may be useful, in fact, to turn it up to make that good. Lord Justice Popplewell's judgment at paragraph 90, which is page 175 of the bundle. At the beginning of paragraph 90, as to the use of the cargo by the Republic of South Africa in 1942, I agree with the judge that the silver was in use by the RSA for commercial purposes when it was on board the vessel. The use consisted of the Republic of South Africa making arrangements for the silver to be put on board the vessel and carried to South Africa by sea. That was the use which gave it its status as cargo for the purposes of the maritime law of salvage. And then similarly, Lady Justice Andrews, paragraph 114, page 180, where she said the claim for salvage arises from the fact, this is in the middle of the paragraph, the claim for salvage arises from the fact that the cargo was exposed to the perils of the seas through a maritime adventure. And in such a case, the maritime adventure would have been a commercial one because the vessel was a merchant vessel.
So you say basically that eliminates the point of asking about the cargo, because it means every time it's on a merchant vessel on that basis, it's being carried, the cargo's being carried for commercial purposes.
It erodes entirely the distinction between section 10.4a and section 10.4b. And therefore we submit that it cannot be the case that the relevant inquiry with respect to cargo can be answered by reference to whether it was being carried pursuant to a commercial contract of carriage. It is fair to say that Maloney Friends don't simply rely on the fact that it was being carried pursuant to a commercial contract of carriage. They also rely on the fact that it had been purchased pursuant to a commercial contract of sale from the government of India. But in our submission, if the fact that it's being carried on commercial terms cannot colour the view as to whether the cargo is in use, all the more so the fact that it had previously been purchased on commercial terms can't be relevant. So if we're right in relation to the contract of carriage, that can't be relevant. It's difficult to see how a sale contract which had been completed before the cargo even embarked on its voyage could be relevant to deciding whether the cargo was in use. And in our submission, considering the matter in this way, is a principled distinction between in personam claims and in rem claims. And that's a distinction which Lady Justice Elizabeth Lang recognised at paragraph 136 of the Court of Appeal judgment, which is at core page 187, where she said, "I'm not persuaded that considerations relating to the cause of action in salvage can be relevant to the construction of the word cargo. Section 10.4a is not expressed to apply and does not apply only to salvage claims." And that is the error that the Court of Appeal made by looking at the cause of action in salvage and considering when the facts that gave rise to that cause of action arose, and that they therefore influenced the consideration of whether the cargo was in use.
Just going back to your prior sale contract, what if the...
Sorry, my lord.
Going back to your prior sale contract point, so what happens if the goods are purchased afloat? How does it work then?
Our submission would still be that if they were purchased afloat for a purpose which was a sovereign purpose, the goods would then be, or the cargo would be intended for use in commercial purposes. The cargo would potentially be being used by the seller for commercial purposes, because the seller needs to sell the cargo. That is the purpose for which they're using the cargo. But that doesn't mean the buyer is in that context using the cargo for commercial purposes. They are simply buying it, and again, their purpose in buying it is the sovereign purpose, and it's still not in use by them for any purpose at all until it arrives at destination in accordance with the sovereign purpose and is used for that purpose. But one would still come back to the fact, in those circumstances, that the contract of carriage, which on that posit would have been made by the seller, doesn't colour the use that the buyer is putting the cargo to. So the buyer is not using the cargo for the purposes of the contract of carriage. It still comes back to the fact that the use is of the vessel for the benefit of the cargo, not the other way round. And in our submission, applying the ordinary and natural meaning of the words in use or intended for use for the commercial purposes, the silver was not in use for any purpose in 1942. It was simply being carried. The word using in our submission connotes doing something with the silver, not doing something to it. And the Union was not doing anything with the silver in 1942, except waiting for it to arrive at Durban and be taken to the mint to make coins. Silver was being carried, not used, and it was being carried, as I've said, for non-commercial purposes to get it to the mint. And the fact, and this possibly goes back to my Lord Legate's point, the fact that although the drafter contemplated the possibility that a cargo might be in use by using the words in use or intended for use, both in relation to the ship and the cargo, does not in our submission mean that there's a requirement in every case to identify a use and identify an intended use and establish that they are non-commercial. It is entirely possible that a cargo on board a ship is not in use at all, and indeed in our submission, as Lady Justice Lang accepted at paragraph 141 of her judgment, page 189, in most cases, a cargo will not be in use during the voyage.
When will it ever be in use, in your case?
I think a number of possibilities have been posited throughout the case. One is, for example, a liquefied natural gas cargo, where the owner of the ship is permitted to use gas that is boiled off when it's above the boil-off rate. So sometimes the cargo could be used in that sense. Lady Justice Lang postulated another possibility, perhaps going back
Yes.
before such cargoes, of a coal cargo being used for the purposes of propulsion.
Is it then a cargo?
Well, in the sense that it's been put on board pursuant to the contract of carriage, yes. But again, I come back to the fact that even if I can't give any examples of the cargo being in use, the phrase in use or intended for use, certainly in section 10.4a, is used both in relation to the ship and the cargo. And there would be nothing surprising, indeed, in our submission, it would accord with the ordinary meaning of the words if one held that the ship was in use and the cargo was intended for use.
It's not unknown for oil tankers to siphon off some of the cargo for bunkers, but that probably wouldn't count.
Well, for bunkers or for sale, I think some of the cases deal with. But again, I don't think that would count because that would be a use that was specifically not authorised. But as I say, the fact that I can't give examples other than perhaps quite extreme examples of a cargo being in use doesn't mean that denudes the words in use in the section of any purpose. Because, as I said, it's a yes-no answer for both questions, and it's simply keeping the options open for the claimant. If they can establish a use or an intended use of the ship and the cargo that is commercial, then they establish that the state is not entitled to immunity. There's no onus on the state to look at the use and the intended use of both the ship and the cargo and establish that they are all non-commercial. Although, of course, in this case, we have satisfied in front of the judge, and there's no appeal from this, the burden of showing that the intended use is non-commercial.
So if I want to drive from London to Rome in my car, and I do so by ferry route rather than the tunnel, I use my car down to Dover, and I my car from Calais down to Rome, but I don't use my car across the channel. Is that right? Because it becomes part of a ship's or vessel's cargo.
Well, on that example, I'm trying to think through all the consequences of this, but on that example, I suspect my lord would still be using the car even when it's on the ferry if, for example, all my lord's luggage was in the car. So the car would be carrying your luggage, the ferry would be...
But the luggage is part of the cargo, isn't it? So I'm not using the luggage either. Ferries are quite tough about not letting you down on the car deck once it's left harbour. As far as I can recall. I just want to see how absolute the concept that carriage as cargo means is.
Well, in terms of a cargo such as the silver, what one is looking at is the fact that in general terms, a cargo will, in our submission, not, as I've said, be in use, because the owner of the cargo wants to do something with it when it arrives at the destination. That is,
but he wants to get it there too.
Indeed, but that doesn't mean that while it's being got there, it's in use. The ship is in use for the purposes of getting there, but the cargo is not in use until it arrives at its destination and something is being done with it. So during the carriage, a service is being provided to the cargo rather than the cargo providing the service of its eventual intended use to the cargo owner. So to take my lord's example of the car, the service is being provided by the ferry company to transport both the car and its passengers and the luggage. So the ship is in use, the ferry is in use. But at that stage, there's no use being made of the car. It's simply sitting on the car deck waiting to arrive at destination and be driven again.
I suppose the position might be different if it was one of those little ferries where you sat in the car while it was crossing a Scottish loch. I mean, it does seem to be slightly dependent upon the nature of the thing.
My lord, yes, and that in our submission would not be surprising because one is considering whether property belonging to a state is entitled to immunity. And without wishing to take the analogies too far, if a state-owned car was on board the ferry, then is it being used for any state purpose while it's on the ferry? Not until it arrives, and then somebody can get into it and be driven around in it. So the purpose is to get it to destination. That's when it will be used. Whereas while it's on the ferry, it's simply having a service provided to it by the operator of the ferry. And indeed, the matter, the point we're debating, in one sense, cuts both ways, because if one focuses purely on use, which is what the majority of the Court of Appeal has done, one is effectively ignoring the importance of looking at intended use. And that's, in fact, something that Lady Justice Andrews seemed to recognise in her judgment at paragraph 124, when she postulated the possibility of an intended use for the cargo and said that a claim to salvage might arise before the ship has embarked on her intended voyage. But in our submission, that can't work, because if the cargo is not yet on board the vessel, it can't be the subject of salvage. And if it's on board the vessel, then the voyage has begun. So it's, again, not in use, it's being carried, and it's the intended use that matters. And it's also important to note in our submission, if my lords have section 10 open at page 175, that section 10.2, dealing with the claim against the ship, also draws the distinction between use or intended use. And I think that's the point my Lord Justice Leggett Lord Leggett was making. If it's difficult to see when you can have an intended use for a ship, it's difficult to understand why those words are in section 10.2. State is not immune as regards an action in rem against the ship if at the time when the cause of action arose the ship is in use or intended use for commercial purposes. So again, we've got the same phrase, in use or intended for use for commercial purposes, in section 10.2, applying only to the ship. And therefore, what appears to be the case is that the drafter of the section has used that phrase as a byword for deciding whether there's a sufficiently sovereign use or intended use of the ship or the cargo. And that phrase has been used in relation to the ship in section 10.2 and in relation to the ship and the cargo in section 10.4.
I mean, in section 10.2, it might work, your sort of examples for intended use of the ship. The problem when you get to 10.4 is that it is postulating ship carrying cargo.
Indeed. But it is the same phrase used in both sections, notwithstanding that potential difficulty. And we submit that in circumstances where, as I've said, Sir Nigel Tier concluded that the cargo was intended for use for commercial purposes in 1942, and indeed he rejected a submission that it was intended for use for commercial purposes in 2017, on that basis, if we're right as to the meaning of the word in use, the appeal must succeed. And there's nothing surprising in that conclusion or lacking in principled reason, because that doesn't mean that Argentum is left without a remedy. It simply means it cannot invoke the in rem jurisdiction of the court rather than the in personam jurisdiction of the court. And that's why I then want to move on and look, if I can, at the nature of Argentum's claim for salvage, which gives it the right to bring the proceedings in rem generally. The only claim that is live at this stage is the claim for salvage. The claim form originally contained a number of other claims relating to ownership of the cargo and the powers of the receiver of wreck, which have all fallen away as a result of the unappealed decisions of the judge as to ownership and the decisions of the Court of Appeal in relation to Merchant Shipping Act matters. And Argentum's claim for salvage is made pursuant to Article 12 of the Salvage Convention. It's at page 2033 of the authorities. I don't think we need to turn it up at this stage. And it's common ground that the claim is not based on any contractual right against the government. It doesn't relate, the claim in salvage doesn't relate to any commercial transaction or activity entered into by the government. And if it did, Section 3 would be engaged, and it's common ground, as I've said, that it's not. A liability in salvage in those circumstances is something that is simply imposed on the property as a matter of public policy. And again, that's common ground. It's paragraph 17 of Argentum's written case at page 99 of the core bundle, and the authorities referred to there, which we don't need to go to. And it's also common ground that the claim for salvage, if good, falls within the Admiralty jurisdiction of the High Court, defined at section 20, subsection 2 of the Senior Courts Act, which in turn lists claims in the nature of salvage of one of the claims within the Admiralty jurisdiction. That's section 22, subsection J. It is also common ground that the claim, if good, is one that can be pursued in rem. And that is because, but only because, salvage gives rise to a maritime lien. And again, that's common ground, but see, if necessary, I think that the easiest case is the Veritas at page 1671, and in particular 1678 of the authorities. And that means that the claim falls in section 21.3 of the Senior Courts Act 1981, which lists the claims that can be pursued in rem, and it lies against the cargo because that's the property on which the maritime lien attaches. And it is also...
It's an intrusion with property right, then?
My lord, that's entirely the process I'm going to come on to develop, but yes. So because of the maritime lien and the ability to proceed in rem against the property, even if it's at this stage only invoked for adjudicative purposes, it is our submission that it's an intrusion against the property right. It significantly impacts or impairs the state's right as owners of the property.
Is there a clear distinction in this context between adjudicative jurisdiction and enforcement jurisdiction? There
is a distinction because they're two different things. In our submission, there is not a clear distinction. An action in rem is a hybrid. The cases say that, and I think that's common ground between the parties. And the point I'm going to go on to make to my lords is that when one looks at the nature of a claim in personam, the two are so inextricably linked that one cannot really simply say, this is a claim in personam, this is a claim in rem, this is a claim in rem that only invokes the adjudicative jurisdiction of the court, and this is a claim in rem that goes further than that.
In this appeal, are we only concerned with the adjudicative aspect of jurisdiction?
In one limited sense, yes. So far, all that has happened is that the claim form has been served on the Res, and my clients have acknowledged service. But in another sense, no, because the service of the claim form, firstly, opens the door to the other parts of the Admiralty in rem jurisdiction, and secondly, gives rise to the consequences which I'm about to address the court on. So, although Argentum can say, at this stage, we're only inviting the court to exercise its adjudicative jurisdiction, nonetheless, for the purposes of considering section 10.4a, that's not a limitation that's built into the test in the section, and therefore one has to simply look at an Admiralty claim in rem, which is what 10.4a is concerned with, and look at the test. And it would be surprising in our submission if a different test applied to section 10.4a if the claimant was only invoking at this stage the adjudicative jurisdiction, given the fact that in due course they can invoke the enforcement jurisdiction. And I'll bring it forward. I was going to postulate the following example.
Before you do that, can I just ask, if we were concerned with enforcement jurisdiction, would it still be section 10.4a, which would be the governing provision?
It would be 10.4a and 13.4.
Well, that was coming 13.2 and 13.4.
My lord, but it would be both. And this is the important point, which is why I said there is a distinction, but it's not a clear distinction. To get within 13.4, so enforcement, and therefore the potential of sale of the Res, one has to go through essentially 10.4a because one has to have issued and served a claim form in rem. So
can you can arrest cargo, presumably, can you, in the same way as you can arrest a ship in the claim in rem?
You can arrest cargo, my lord, yes, and the point I was going to make is this. If the claimant in this case, or any other salvage case, had issued its claim form in rem, but anxious to preserve its maritime lien, also sought a warrant of arrest in relation to cargo, sought to arrest the cargo. The cargo is then arrested. In due course, it can be appraised and sold by the court, and in due course there could be a judgment in default. And so the in rem proceeding and the enforcement aspects are inextricably linked. So again, if one sought to draw a bright line between adjudicative and enforcement proceedings, one would end up in this situation. If Argentum had applied for the arrest of the cargo, as well as served the claim form in rem on it, and if we had then applied to set aside the claim form and the warrant of arrest, we would have come before the Admiralty judge on both those applications. The evidence as to use and intended use would be exactly the same, yet on my learned friend's case, effectively a different test as to what the use of the cargo was would apply for adjudicative jurisdiction as opposed to the enforcement jurisdiction. I'm going to go on later to look at the cases in relation to section 13.4, so in one sense I'm skipping ahead, but the cases in relation to section 13.4 I was going to deal with this afternoon, so particularly Savas in the Supreme Court, make it clear that one looks at the intended use of the cargo, or potentially the actual use if it's in use, or the property being enforced against, not the circumstances that gave rise to it being property in the possession of the state. And in our submission, it is quite clear that on the section 13.4 authorities, the approach that Argentum contends for of looking at the sale contract and looking at the contract of carriage is not a permissible approach. Yet one would be in the situation if one had a warrant of arrest as well as a claim form, where for the purposes of setting aside the claim form or granting immunity or recognising immunity in respect to the claim form, one would apply my learned friend's approach and look at how the cargo came to be cargo, how it came to be purchased, how it came to be carried, yet applying Savas, when one came to look at the warrant of arrest, one would not be permitted to look at all that. So one would end up in a situation where the court may well, and in fact this case we submit would, be driven to find that if my learned friend is right, for the purposes of the claim form, the cargo was in use, but for the purposes of the warrant of arrest, the cargo was not in use for commercial purposes. And that I hope answers my Lord's question about whether there's a clear distinction, because if you had an arrest as well as a claim form in rem, there would be no material distinction.
So if we were to decide on this appeal that there's no immunity from an action in rem, does that mean there'd be another round where a question of immunity would be raised in relation to enforcement jurisdiction?
My Lord, that would depend on the approach my clients took to the claim in rem, given that they had no jurisdiction, and which actually fits very neatly into the point I was going to make next. It's that if there's no immunity in rem, the in rem defendant, so the state owner of the property, is essentially put to an election of either submit to the jurisdiction or essentially take the risk of forfeiting your property. And I'll make that good in a moment by looking at the cases on that. And I can't tell my lords what approach my clients would take, but they would either have to take part in the action going forwards and perhaps take their stand on whether the claim was time barred, or simply not serve a second acknowledgement of service, in which case my learned friend's clients would be entitled to apply for judgment in default. They would no doubt put in their evidence of having performed salvage operations to the judge. They may or may not satisfy him that they were the salvor and were in time, but assume in his favour that his case is good, he will get his judgment in default. He's then entitled to apply for a warrant of arrest and sale, and then the court would have to consider all over again whether the cargo was immune from the enforcement jurisdiction of the court.
Well, that was what my question was directed to. Thank you very much.
Indeed. And indeed, that sale, at one point in my learned friend's submissions, they say, well, all of that depends on first having persuaded the court to exercise its adjudicative jurisdiction. But in our submission, that's not right, because the Admiralty jurisdiction to order a sale of the rees which is under arrest includes a jurisdiction to order a sale of that rees pendente lite, so prior to the judgment. So there's even a risk, and to postulate the extreme example, obviously my clients have acknowledged service, but where you have an in rem claim form, which can be served on the cargo without giving any notice of that to the owner of the cargo, one can end up in a situation, if the state is not immune in respect of in rem proceedings, where the in rem claim form is served on the cargo, judgment in default is obtained, the cargo is appraised and sold, all without the state owner having any knowledge of this taking place. Now, I accept that that's probably unusual, and particularly if the state has an intended purpose that it wishes to carry through, it is probably very unusual or unlikely, because it's going to want to know where its cargo is and where it's going. But nonetheless, it is a consequence of the in rem procedure. The claimant is entitled to proceed in that manner and ultimately invoke the enforcement jurisdiction of the court. And so that's why, although notionally there's a distinction, to go back to my Lord's original questions, there's not a clear distinction, because you simply can't unravel the two. They are intertwined.
Right. So you say that if a warrant of arrest were issued, and if we were concerned here with a warrant of arrest, that will be governed by Section 10.4 and also by 13.4.
The warrant of arrest would be governed by Section 13.4, but you would still have had to have issued your claim form. The immunity in relation to the claim form is Section 10.4. And Section 13.4 uses, as my lords are aware, the same language to determine whether there should be immunity or not. And I say I will be coming on to look at the Supreme Court decision in Savas this afternoon. But for present purposes, the highlight, or as it were, the roadmap of where I'll be going on that is the submissions I've just been making.
Thank you very much.
And so the significance of all of this is that, I say, the claim in rem for salvage lies against the cargo and can be brought against the cargo from the moment the services were provided. And although we accept that a claim in rem against cargo will invariably arise in the context of salvage, it is important that I should just deal with this point before going back to the point I diverted to. The Court of Appeal considered that Section 10.4a was in effect and should be treated as and read as a provision relating to salvage. And the logic of that was that there are very few claims that can be pursued in rem against a cargo. Salvage is the only one that comes readily to mind, and that therefore one should treat Section 10.4a as if it was referring to claims in salvage. And in our respectful submission, the majority in the court erred in that approach, because although the other claims within the in rem jurisdiction of the court are unusual, I think it would be a fair way of putting it, there are other claims. They're set out in Section 21S of the Act, at page 1690 of the bundle, but in particular they include a claim for forfeiture or condemnation of the cargo, a claim for restoration of a cargo after seizure, and a claim for droits of admiralty. Now, all of those I accept are unusual claims, do not arise very often. I have to say I don't think I've ever seen any of them in practice, but that nonetheless does not mean that one should be looking at Section 10.4a as if it only ever applies to cargo.
Where did you say those claims are listed, sorry?
My Lord, I apologise. Section
21S
1S of the Civil Courts Act, Authorities Bundle 1690.
And two.
Subsection 2, isn't it?
2, isn't it?
I do apologise. I'm giving myself a wrong reference.
Right reference, but it's just the wrong subsection. The last.
Yes, Section 20, subsection 2S,
Yeah.
1690. And those are the only claims, apart from a salvage claim, that can be pursued in rem against cargo. And therefore, the existence of those other claims, however rarely they may arise in practice, means in our submission that it cannot be assumed that the drafter of Section 10.4a only had in mind claims in salvage. If Section 10.4a was only intended to refer to claims in salvage, it could and would have referred to claims in salvage against cargo. Instead, it refers to claims in rem. And in that respect, in our submission, the Court of Appeal attached too much weight to identifying what it called the ingredients of the cause of action in salvage, the maritime adventure and so forth. That inquiry focuses on why the government, as owning the cargo, incur a liability in salvage. But that tells the court nothing in our submission about whether it should or should not be immune from proceedings in rem. And as I said, Lady Justice Elizabeth Lang, in her judgment, paragraph 138, said that considerations relating to the cause of action in salvage are not relevant to the construction of the word cargo, and that the silver was cargo for the purposes of 10.4a simply because it was in the hold of the vessel. And that, in our respectful submission, is the correct approach. And so it is necessary in our submission to consider, and we've obviously looked at this already, so I'll take this as briefly as I can, that the real significance of the fact that the claim can be bought in rem is that necessarily involves interference with the rights of the cargo owner. And those are summarised in a decision of Mr. Justice Tier and the Stiliani Z, which is at tab 14 of the Authorities Bundle, page 1086. And it's also in the supplemental bundle in the Lloyd's reports. But if I can take these points, and I think they're all common ground, so I hope I can take them without going back to the judgment.
Sorry, 1086, you say?
1086 in the original Authorities Bundle. The Lloyd's Law report version has been provided at page 3 of the supplementary Authorities Bundle. But Mr. Justice Tier, then the Admiralty Judge, summarised in our submission correctly the consequences of the claim being permitted in rem.
Which paragraph is it?
Paragraph 47.
Thank you very much.
At 1097. Firstly, there's a clear distinction between proceedings in rem and proceedings in personam, which is of particular importance in relation to service. And so at this stage, note that the learned judge is talking about the purely adjudicative aspects of the claim. The in rem claimant has, and these are just examples of the important differences, 12 months in which to serve the claim form rather than 4 months. The in rem claimants with a claim over cargo can bring the cargo to this jurisdiction and then, as I've said, serve the claim form simply by fixing a copy to the property, establishing jurisdiction even if the owner is out of the jurisdiction, has never been served personally and has no knowledge of the claim. Next, the in rem claimant is entitled to apply, we've touched on all this already, for judgment in default under Rule 61.9 of the Civil Procedure Rules if there's no acknowledgement of service, and that's why I said my clients would be put to their election of either acknowledging service or submitting to a judgment in default. And an in rem claimant can apply for the arrest under CPR Part 61.5 and appraisement of sale. As I said, they don't have to wait for a judgment to do that. So if the claim in rem is permitted, the owners of the cargo can, and I'm going back, but just to summarise, find themselves in a position where the cargo has been served, arrested and sold without ever becoming aware of the proceedings in rem. And these are all significant consequences which justify the difference in approach in our submission between Section 10.4a and Section 10.4b.
Can you help me? Is judgment in default not available under a claim in persona?
No, clearly it is available in relation to a claim.
It's not a distinguishing feature of a claim in rem.
No, but
it's just that combined with the peculiar method of service, it has some nasty traps for the unwary defendant.
Or the unknowing defendant, might be.
Yes.
So it's a combination that makes it significant, yes. So, yeah. And in our submission, where a cargo is state-owned, each of these consequences represents a substantial interference with the state's rights to deal with its property. And one can make that submission good by just looking, if I may, briefly at a number of cases which my lords have in the bundle, starting with the Parliament Belge at page 1273. This is a case that Mr. Wordsworth will come back to later on, but for present purposes, at 1295, I just want to highlight one passage. Which is at page 219 of the judgment, 1295. Dealing with the question of whether the maritime lien and the claim in rem impledes the owner of the cargo, about 5 lines down, the case of the bold Beclue does not decide to the contrary of this. It decides that an action in rem is different from one in personam and has a different result. But it does not decide that a court which seizes and sells a man property does not assume to make that man subject to the jurisdiction. To implead an independent sovereign in such a way, and that's to service the claim form in rem, is to call upon him either to sacrifice his property or his independence. And so that's the Court of Appeal in the Parliament Belge. And that position we submit is true today as it was at the time of that decision. To place the sovereign in that position is a breach of the principles on which his immunity from jurisdiction rests, because the consequences of the in rem claim are to put the sovereign to that election. Similarly, in the Tveit, which is at page 1601 of the authorities bundle, this was a collision case rather than a salvage case, but also involved a maritime lien over the ship. The case was principally concerned with the issues relating to the maritime lien and whether a maritime lien could attach to property owned by a state. That's what the decision is principally reported on. But we rely on what Lord Justice Banks observed at page 267 of the judgment. So 1609 of my Lord's bundle, or beginning 1608. A maritime lien is the foundation of the proceedings in rem, which is a process that makes inchoate
Sorry,
the right.
reading from the bottom.
Where are you?
I'm at the bottom of 1608.
Ah, yes, the very
Oh,
last
I've got it
line.
halfway through a sentence.
So, again, there's a reference to the bold Buccleuch, and beginning after the semicolon in the penultimate line at 1608, he then goes on to say that a maritime lien is the foundation of the proceedings in rem, a process that makes perfect a right inchoate from the moment that the lien attaches. And then towards the bottom of the page, of that paragraph rather, to allow such a lien to attach would be, to use the language of Mr. Justice Gorrell Barnes in the Ripon City, to create a jus in re aliena, a subtraction from the absolute property of the state.
Sorry, where's that last bit?
It's the last two lines of the paragraph, the first paragraph on page
Oh, yes.
267
Yes.
of the judgment.
Yep.
And Lord Justice Banks also observed, if we turn back one page to page 1608, halfway through the paragraph beginning in spite, Lord Justice Banks also observed, if the judgment of the President is right and the maritime lien attaches to vate, the value of the vessel to the Belgian government must necessarily have been affected. And we submit that for maritime lien can also read right to proceed in rem.
The passage you've just read, I'm very sorry, is
1608. I'm sorry, my lord, I should have taken it more slowly. Paragraph beginning in spite of, so that the only main paragraph on the page.
Yes.
Almost exactly halfway through that paragraph.
Yes.
If the judgment of the President is right,
Yeah.
and the maritime lien attached to the tevate, the value of the vessel to the Belgian government must necessarily have been affected. And one can see how that applies equally in our submission to a claim in rem. If your vessel is subject to a maritime lien and the right to proceed in rem, with all the consequences we looked at, the value of the vessel is necessarily impeded, as we've just seen, and the same would apply equally to the cargo. One's ability as the state owner of that cargo to do what one intended to do with it, to use it for its intended purposes, is necessarily impeded. There are similar dicta which we refer to in our written case in the Christina, which my learned friend will be dealing with when he comes to his submissions in due course. So I'm not going to trouble the court by going to the Christina as well. But there's a useful summary in the Sultan of Johor case at page 1590 of the authorities bundle. Which is why I'm not going to take my lords to the Christina or the other case. And at the top of page 1590, the first full paragraph, an action in rem against a ship impledes persons who are interested in the ship. We respectfully submit the same is good in relation to cargo. That is settled law. And in our submission, I say, that applies equally to cargo. And therefore, the consequences I've outlined of the claim in rem being permitted against a state-owned cargo significantly affect the state's rights of ownership and rights to dispose of the sovereign cargo. Where the state has a purpose, a settled intention as to the use of that cargo, it significantly impairs the state's ability to bring that purpose to being. And that is why, in our submission, Section 10(4)(b) needs to be construed in a way that recognises that it opens the gateway, if I can put it that way, to the enforcement jurisdiction, and in any event carries with it the necessary implication that cargo is going to be detained. My lords, I'm conscious of the time, and that my lord indicated there would be a break for the transcriber. I've got about 5 more minutes to go before I've finished and would be handing over to Mr. Wordsworth. So if I can just finish those submissions.
The final extract you read was at page 1590. Thank you.
Yes, my Lord, yes, 1590.
Thank you.
So it was the first full paragraph begins in an action in rem.
That's it. Got it. Thank you very much.
And so, and this perhaps is just to go back to something I've already referred to in the submissions in answer to questions from my Lord, as to the distinction between adjudicative enforcement. But Argentum make much, as the court will be aware, of the fact that proceedings in rem are a hybrid, and of the fact that at this stage the court, they say, is only asked to exercise its adjudicative jurisdiction. And they need to do so, as I've submitted to my Lords and will come back to this afternoon, in order to distinguish between the Section 10.4 position and the Section 13.4 cases. But we say, and if I can just recap to make sure I didn't leave anything out in responding to questions this morning, Argentum's position in relation to that distinction is wrong for 5 reasons. Firstly, even insofar as the in rem proceedings are adjudicative only, they still represent a significant interference with the rights of the property owner. We've been through the reasons why, but the necessity to be put to one's election is perhaps the principal one. Secondly, and relatedly, if a claimant wishes to enforce by arrest, they need to issue the in rem claim form first. And again, that comes back to the point I already made, that the two go hand in hand. Thirdly, if Argentum's point were good, when it was appropriate to focus on purely adjudicative proceedings, there would be no need to distinguish between the in rem procedure and the in personam procedure in 10.4a and 10.4b, because the access to the purely adjudicative procedure is through the in personam route. Fourthly, as we refer to in our written case, and by analogy to the provisions in relation to the Crown under the Crown Proceedings Act, and the reference, I don't think we need to turn it up, but the reference is 1684 of the Authorities Bundle. Proceedings against the Crown are prohibited irrespective of whether the claimant is invoking an adjudicative or enforcement jurisdiction, simply a blanket prohibition on claims in rem. And fifthly, as Mr. Wordsworth will deal with shortly after the break or immediately after the break, the Brussels Convention treats all claims in rem in the same manner. So it simply refers to enforcement and other matters, and then proceedings in rem. And then finally, just on the distinction between adjudicative and enforcement, the provisions of Section 10.3 of the State Immunity Act are relevant. And they are set out at page 1701, and these concern cases of sistership arrests. And in the case of a sistership arrest, where the claim arises in relation to one ship, but the claimant is entitled under the Act to proceed in rem against another ship, the Act requires the court to consider whether both ships are in use or intended to use for commercial purposes. So to bring oneself by arresting a sister ship within the jurisdiction of the court, it is necessary to show not only that the guilty ship, if I can use that phrase, was in use or intended for use for commercial purposes, but the wholly innocent ship, which is merely a tool to establish jurisdiction, is also in use or in use for commercial purposes, in use or intended for use for commercial purposes. And so in our submission, there are very good reasons why Parliament applied a different test for in rem than in persona. And they reflect the fact that even at the very outset, at the purely adjudicative stage of in rem proceedings, they represent a substantial interference. And that is why it is necessary to approach the manner in which we submit and attach sufficient weight to the intended use of the cargo referred to in section 10.4a.
Thank you, Mr. Smith. We'll take 5 minutes now. Mr. Wordsworth.
My Lords, as already indicated, I'm going to be dealing with 3 topics. The first topic, the role played in the interpretation of section 10.4 by the 1926 Brussels Convention, and in particular its Article 3.3. Secondly, I'm going to look at Argentum's case on customary international law, which, as with the majority's analysis, is very much built on certain aspects of Lord Wilberforce's well-known speech in Primo Congresso. And finally, I'll be looking at the impact of Section 3 of the Human Rights Act, if, contrary to South Africa's case, the immunity afforded by Section 10.4a exceeds that granted or required by customary international law. So, my Lords, if I can start with the Brussels Convention, and it is common ground that Section 10 of the Act was drafted specifically in order to give effect to the 1926 Convention and to enable its ratification, a point that is also noted by Lord Sumption in Benkebusch at paragraph 10. That's Authorities, page 625. No need to turn to it now. It is therefore also common ground that your Lordships can and should be looking at the Brussels Convention in order to assist in the interpretation of Section 10.4, as of course did the judges in the Court of Appeal, each in fact in some detail. And as your Lordships will also be aware, there is a well-established presumption that where a statute is passed in order to give effect to the obligations of the UK under a treaty, the statute should be given a meaning that conforms to the treaty. A natural and fairly obvious point. Argentum makes the point by reference to the Court of Appeal decision in the Prestige, citing in turn Lord Diplock in Alcom, and this is page 1135 of the Authorities. Lord Diplock noting that in the context of the State Immunity Act and customary international law, it was highly unlikely that Parliament intended to require the UK courts to act contrary to international law unless the clear language of the statute compelled such a conclusion. And of course that applies a fortiori where the drafter's specific intention, as in Section 10, was to give effect to specific rules of international law, i.e. the Brussels Convention. There is a minor issue in that in its written case, Argentum seeks to downplay to some extent the importance of the Brussels Convention in the interpretive process, saying at paragraph 54.2 that the link between the Brussels Convention and the State Immunity Act is relatively weak, diminishing the strength of the Brussels Convention as an interpretive tool for the SIA. But it offers no basis at all for that assertion, and it does not follow from the fact that the drafters did not just adopt the language of the Convention. Of course, there are many ways that English statutes seek to give effect to obligations of the UK under international law. There is no set method. If I can turn then to the Convention and to its interpretation, of course it's common ground that the Convention has to be interpreted according to the usual rules, customary international law rules reflected in Articles 31 and 32 of the Vienna Convention on the Law of Treaties, and of course under Article 31(1, the focus is on the ordinary meaning of the words in their context and in delight of the object and purpose of the treaty. If I can ask you to turn to the treaty, which is at 1986 of the authorities, and ask you, the French version comes first, so
Page?
Page 1996.
Sorry, I misheard you. Thank you.
1986 is the beginning of the treaty. 1996 is where we're interested in the English text.
Yeah.
Article 1. I just would like very briefly to take you through Article 1, 2 and 3 before we get to Article 3.3, just so you see how it fits in within the overall scheme of the Convention. Article 1 sets out the basic rule on liability with respect to state-owned ships and cargoes. And you see from Article 1 that that basic rule is that seagoing ships owned or operated by states, cargoes owned by them, and cargoes and passengers carried on state-owned ships, as well as the states which own or operate such ships and own such cargoes, shall be, as regards claims in respect of the operation of such ships or in respect of the carriage of such cargoes, to the same rules of liability and the same obligations as those applicable in the case of privately owned ships, cargoes and equipment. That's liability. Article 2 then deals with jurisdiction and establishes that as regards such liabilities and obligations, the rules relating to the jurisdiction of the courts, rights of action and procedure shall be the same as for merchant ships belonging to private owners and for private cargoes and their owners. And then in Article 3, there is an important series of carve-outs from those two basic rules. First of all, you have Article 3(1), which expressly disapplies the first two rules in relation to ships of war, state-owned yachts, and the like, and the defining reference is by reference to other vessels owned or operated by a state and employed exclusively at the time when the cause of action arises on government and non-commercial service. And then it's specified in addition, and such ships shall not be subject to seizure, arrest or detention by any legal process, nor to any proceedings in rem. And just to recall the point made by Mr. Smith just before the break was to identify how the Brussels Convention in fact is treating in rem as part of the package with respect to seizure and arrest or detention. The way the provision then works is to allow certain claims nonetheless to be brought in front of the appropriate courts of the state which owns or operates the ship. And it's stated that there is no entitlement to immunity in relation thereto. So the basic rule in relation to these ships is that there is immunity but the claimant has the opportunity to bring a claim before the courts of the state owning or operating the ship.
So it wouldn't really be a case of immunity at all, would it?
Well, it is described in the convention as being a convention that concerns immunities. But in front of the domestic courts, no. Of course, there would be no immunity at all. And it's just saying, here is an opportunity, here is a location, jurisdiction in which to bring your claim. My Lord, the Brussels Convention is fairly characterised as an early adopter of the restrictive theory, but it is still 1926, so I think maybe there is some sort of working out going on, and it wouldn't be phrased in the same way today. Article 3.2 then provides that the same rules shall apply to state-owned cargoes carried on board any of the above-mentioned ships. And then that leads to Article 3.3, which is the key provision for today. State-owned cargoes carried on board merchant ships for government and non-commercial purposes shall not be subject to seizure, arrest, or detention by any legal process, nor to any proceedings in rem. So you have a specific immunity being accorded in relation to the state-owned cargoes carried on board merchant ships for government and non-commercial purposes with respect to the designated grouping, including proceedings in rem. There is then an exception to that basic rule, or rather it's perhaps better to see it as a freestanding rule that allows claims which would obviously exclude claims with respect to seizure, arrest, detention, or in rem proceedings to be brought by reference to the court having jurisdiction under Article 2. And it now appears to be common ground that the first limb of Article 3.3 is dealing with in rem claims, and the second limb is dealing with in personam claims. And that is where, and again I think this is common ground, the drafter got the distinction between 10.4a, which obviously only deals with in rem, and 10.4b, which deals with the in personam claims. And that, in fact, is how it was understood by Lord Justice Popplewell at paragraphs 41 to 43 of the judgment, page 163 of the core. And I understand there no longer to be a debate as to that. So the key question then is what is meant in the first limb of Article 3.3, state-owned cargoes carried on board merchant ships for government and non-commercial purposes. And of course, as a matter of the ordinary meaning of the words, this mandates an inquiry into purpose. That is, for what purposes is the state-owned cargo being carried on board the merchant ship? Both as a matter of ordinary meaning and context, that inquiry does not engage questions as to whether or in what precise way the cargo is being carried pursuant to commercial arrangements, because that point has already been addressed. Article 3.3 only applies if state-owned cargoes are being carried on board merchant ships. So we already know that the state-owned cargo is on board the merchant ship, And of course, in the usual course, there will be commercial arrangements dictating how it got there and a contract of carriage. It's only with respect to the state-owned cargo on board the merchant ship that you then ask the question, for what purposes is that cargo being carried on board the ship? Similarly, as a matter of ordinary meaning and context, the focus is on purposes as opposed to the use of the cargo whilst it is on board the ship. And one can see that in part if one looks back at Article 3.1, where the drafters are looking, or the states parties are looking at the immunity of ships, and that is by reference to the words employed exclusively at the time when the cause of action arises on government and non-commercial service. So that is looking at use of the ship, the type of use of the ship, whereas Article 3.3 is looking at purposes and asking the question, for what purposes is the state-owned cargo being carried on board the merchant ship? And these points are also supported from looking at the French text of the treaty, which is at page 1990, Article 3.3. And of course, this is an equally authentic text, so it is useful to be looking at it in the interpretive process. And you see les cargaisons appartenant à un État et transportées à bord de navires de commerce, dans un but gouvernemental et non-commercial. So, being transported to a governmental and non-commercial aim or goal would be the sense there of but, or of course one can just translate it as purposes. Of course, there's nothing there that is suggesting that you should be looking at whether or not the goods are being carried in a governmental fashion or not, d'une façon gouvernementale. It's just looking at that goal, the aim, the purpose. My Lord, if I can take you to the views of two contemporaneous commentators.
Just before you do, government and non-commercial is either a single concept or at least a cumulative set of requirements, isn't it? May not matter which, but they're not alternatives.
They're not alternatives, no. It's absolutely cumulative, no question about that. So, if I could take you to the views of two commentators, both of whom were closely involved in the drafting process. One of them was a member of the Dutch delegation, and the other was the rapporteur, I believe, for the Brussels conference. Both these pieces are referred to in the 1991 ILC commentary on what became the 2004 Jurisdictional Immunities Convention. If I could ask you to turn to supplemental authorities.
Sorry, you'd have to bear with us for a minute.
Supplemental, we've got
It
supplemental.
hasn't been put in my folder, unfortunately. But
Not sure we've got them. When did they come?
Friday, I believe.
there was an email saying an agreed supplemental bundle has been uploaded, but I can't find it's been uploaded in my case.
Nor can I.
Haven't got it, I'm afraid. why don't you continue with your submissions?
Yes.
And we'll inquire at lunchtime as to what's happened to the bundle. But you can read us the relevant passage from the International Law Commission.
Well, no, my lord, because in the 1991 ILC report, there's just a reference to Van Slooten and to Gidel. Then you look at what they're saying, and both of them, Van Slooten in a 1926 piece that he writes on the convention for the Revue du Droit International, and Gidel in his multi-volume 1932 work on the law of the sea, they both comment specifically on Article 3.3 of the Brussels Convention, and they are of importance really for two reasons. One is just in confirming the understanding of the ordinary meaning, because they're saying that the question is whether the cargo has a governmental and non-commercial purpose. They refer to une destination gouvernementale et non commerciale, or whether it's destined to a governmental aim. But they both explain how the original drafts were much narrower, and Article 3.3, as originally drafted, only concerned state-owned cargoes that were carried on state-owned ships. Now that's important because four of the states, France, Italy, Great Britain, and the Netherlands, were insistent that the scope of Article 3.3 be widened. And the reason they were so insistent, according to the commentators, is that they were coming across a situation where they were using merchant ships for the transfer of armaments and munitions and other materials, and it was important to them that there would be immunity in respect of that property within the context of Article 3.3. And of course that's very important so far as concerns confirming, and this is only confirming the ordinary meaning of Article 3.3. It's a very helpful example that shows one why the provision is there and why it was important to states. And also, if the states were concerned with transfer of armaments and munitions, why would the provision apply in any different way when the goods were equally for a governmental and non-commercial purpose, but it just happened to be a different purpose, that is, the purposes of supplying the mint, as opposed to any form of military supply.
I've asked that the supplemental bundle be uploaded, so you'll be able to take us back to these passages at a later point.
At a later point?
Yes.
Thank you very much, my lord.
What has come as an email?
Anyway, my lord, shall I continue or
yes, we don't at the moment. All of us have the bundle.
Right.
It's being loaded electronically. We'll have it later. Thank you. I'm very sorry about that.
My lords, perhaps to speed up matters, you have the references on the...
Yes. Yes, please.
And perhaps you could look over the short adjournment. Van Slooten is Authority Tab 8, 132 is the beginning of his piece, and it's relevant.
Sorry, supplementary bundle, page?
Tab 8, page 132 at 155.
Sorry, my supplementary bundle seems to conk out at tab 6.
No, mine's just arrived.
And at page 96.
Ah, yes.
We don't really care about the tabs, but at page 132 is the article.
The second page has arrived.
Yes, very good news. If I could ask you to look at 155 in the original, and there's an English translation at 164.
So, all right.
And then Gidel.
Hang on a moment. So you want to look at 164?
Yes.
I think what, according,
Well, this is my translation
Your translation.
at 164.
Right. Got 164.
no,
You want to take us to that?
My Lord, thank you. So far as concerns cargoes, the conference distinguished between the goods carried on board ships mentioned in Article 3 and cargo carried on board merchant ships. Goods on board ships that cannot be seized will, by this very fact, enjoy immunity from seizure according to the ship, on the sole condition that they belong to the state. But the immunity of cargo transported on ordinary merchant ships is subject to a double condition. The goods must belong to the state and have a governmental and non-commercial destination or purpose. In this regard, it should be recalled that the Maritime Committee in the drafts of Gothenburg and Genoa had only wanted to grant immunity to cargoes transported to a governmental and non-commercial aim on board ships owned or operated by states. This very restrictive approach was attacked by the French and Italian associations, to which were joined during the Brussels conference the British and Dutch delegations. One cannot conceive, in fact, as was very well noted by Monsieur Ripert, he was one of the rapporteurs, I believe, at the Gothenburg conference, how a state would accept that one could seize a cargo which it intended for a governmental aim that was transported on a merchant ship. Such a situation is not purely hypothetical. The dangers it poses are not fanciful. Many states use this procedure for the transport of arms, supplies, and munitions intended for the use of their armed forces in their colonies and overseas possessions. The conference ended up by adopting this point of view, and in coming in this way to the way of seeing of the colonizing countries, it removed a serious obstacle to ratification of the convention by these states. If I could ask you also then to turn to the passage Gidel, which is translated at page 130. And this is on a section specifically on rules of the Brussels Convention relating to state cargoes. Really, I can take it from the third paragraph. If government-owned cargo is transported on board a merchant ship, it only benefits from immunity from seizure or other legal proceedings in rem if it has a governmental and non-commercial destination or purpose, Article 3.3.1. The Gothenburg and Genoa drafts were much too severe with respect to state-owned cargoes. They did not exempt such cargoes from seizure under any circumstances when transported on board private ships. Immunity was only accorded to them if they were transported for a governmental and non-commercial aim on board ships owned or operated by states. The Brussels Convention has very opportunely reduced the rigour of these provisions. So, my Lords, a very important indication as to what the parties to the Brussels Convention had in mind with respect to Article 3.3. We say that is entirely confirmatory of the ordinary meaning of Article 3.3, and that it could make no sense to interpret purpose or purposes under Article 3.3 as determined by reference to the commercial nature of carriage and or the existence of a contract of purchase. That goes against both ordinary meaning and the common intention to accord a specific and effective immunity for cargo on board a merchant vessel. Actually, briefly how the Court of Appeal dealt with this. Paragraph 99 of Popplewell, Lord Justice Popplewell's judgment, page 177 of the core, and Lady Justice Andrews substantially agreed with his reasoning. He considered the words for governmental and non-commercial purposes in the Brussels Convention do not mandate an inquiry only as to intended use rather than use. I agree.
So you're reading from 99?
From 99. So it's from paragraph 99, from the second sentence.
Thank you.
I agree with Elizabeth Lane, LJ, that to ask whether a cargo is being carried on a ship for commercial purposes is an inquiry as to why it is there. But to ask why is it being carried does not distinguish between use and intended use. The question may admit of two answers, one being how it came to be there, and the other being what was intended to be done with it thereafter. The former is the relevant question because the context is salvage and what makes property cargo. Against that background, the answer to why the silver was on the vessel as a cargo is not that it was intended for coinage, but that it was put on board for carriage to South Africa under commercial contracts of purchase and carriage. That is what is meant. That is what meant it was being carried for commercial purposes. And my lords, with respect, we would say that there are three flaws in that reasoning. First, it is incorrect to say that the context is salvage and what makes property cargo. There's nothing in the text of the first limb of Article 3.3 that suggests the Brussels Convention parties had specifically salvage in mind, or indeed the question of what makes property cargo, whether by reference to the domestic law of one of the Brussels Convention's parties or otherwise. At this stage of the analysis, Lord Justice Popplewell really is focused on what English law might require, which it would not be a correct approach to the interpretation of this treaty. Second, too much is being made of Elizabeth Jane's formulation as if this formed part of the text. The question that the text of Article 3.3 asks is, for what purposes is the cargo being carried? And the answer to that question cannot be the cargo was put on board for carriage to South Africa under commercial contracts of purchase and carriage. That just leaves unanswered the question of whether the cargo is being carried on board a merchant ship for government and non-commercial purposes. Third, if that question could be answered by reference to the commercial contracts pursuant to which the cargo was put on board, the words for government and non-commercial purposes would serve no purpose. Article 3.3 is only concerned with state-owned cargoes on board merchant vessels. The natural assumption is that there will always be a contract of carriage and most likely some form of contract of purchase. The question is, it's already on board the merchant vessel. What purposes is it being carried? And this is really a point on FAUT, that the interpreter has to give sensible meaning to these key words. And in Elizabeth Lane, Lady Justice Elizabeth Lane, put the point slightly differently, but I think it's still an FAUT point. She said at paragraph 156, which is 191 of the judgment, 191 of the core.
What's the paragraph number again?
Paragraph 156, I'm
Thank
sorry.
you.
Page 191 of the core. She said, if the commercial arrangements which lead to the carriage of a state-owned cargo on a merchant vessel inevitably mean that the cargo is not carried for government and non-commercial purposes, the bar on in rem proceedings in Article 3.3 is wholly redundant. That must be right. Not only would it be right with respect to in rem proceedings, it would also be right with the all-important protection from seizure, arrest and detention. So my lords, we say that the Court of Appeal erred with respect, the majority erred with respect to their interpretation of Article 3.3. Argentum, in its written case, also says that the Brussels Convention must be interpreted against the background of customary international law. I don't recall, I don't believe this was the point it was making in front of the Court of Appeal. But in this respect, it's referring to Article 31.3c of the Vienna Convention, and correctly so, because as a matter of context, the interpreter needs to take into account any relevant rules of international law applicable in the relations between the parties. That would include customary international law, also, of course, conventional law. But Article 31.3c doesn't help Argentum for two reasons. First, what the international law materials show is that in this context of claims against state property, in particular, the focus or the cases and materials concern claims generally against ships owned by a state. The focus of the restrictive theory is on whether the property is in use or destined to a sovereign purpose. It is a purpose test that one sees in this context. It follows that both custom and treaty strongly support giving the wording of Article 3.3 their ordinary meaning. That is, focusing on the sovereign purpose for which a state-owned cargo is being carried, which in almost all cases is going to be the intended use at the destination.
So here we're looking at the state's purpose.
The state's purpose.
Not the cargo owner's purpose.
Absolutely not, my lord. No. I mean,
we were told earlier that we do look at the cargo owner's purpose under Section 10.
Well,
the use of vessels.
My lord, I don't want to trespass into the area of Mr. Smith, but certainly here we are only looking at the purpose of the owner of the state owner of the cargo, or the state.
This only arises if the state owns the cargo in the first place, presumably.
Absolutely right, my lord. Yes. That's
Therefore, we're only concerned with the cargo. We only could be concerned with the state's purpose. With the ship, it might be different, or might not be different.
My lord, yes. And the Brussels Convention, as far as concerns ships, it is only concerned with state-owned ships or operated ships. And there's the protocol that deals with the situation of ships chartered by a state. Essentially, you've always got to be looking at the state and the purpose of the state. And the second one I just wanted to point to by way of introduction to the customary international law and general international law issues is that the restrictive theory is context dependent. And in the context of state property, and in particular state-owned ships, the focus is not on the transactions pursuant to which a ship has been acquired or is being operated, but it is on the purpose for which the vessel is being or is to be used. Now, most of the materials concern state-owned ships rather than cargo. The Brussels Convention is obviously an exception to that, but ships are the closest analogue. And as a matter of principle, an in rem claim against a state-owned cargo should be approached in the same way as an in rem claim against a state-owned vessel, because both are a species of state-owned property as to which, to borrow the words from the Parlement Belge, to which I'll come back a little later, there is no jurisdiction in the English court to divert the public property from its destined public uses. That, of course, makes complete sense. You're talking here about the property of the state. The state needs to have access to its property. It needs to be able to use its silver to mint the coins. It needs to be able to use the munitions to supply to its army. The context of the in rem claim, or the context of any claim that is directly interfering with the property rights of the state, is completely different to the context of the in personam claim. That is why, of course, one sees that reflected in the two separate limbs of Article 3.3 of the Brussels Convention, and then again, as the drafter correctly identified, in 10.4, between 10.4a and 10.4b. My Lords, if I could take you then to some of the international law materials, some of which is customary international law, and just to recall that customary international law plays a role in terms of having to be taken into account in an interpretation of the Brussels Convention. That's Article 31.3c. Of course, it forms the background against which the 1978 Act is to be interpreted, although here it does play a rather different role to usual, because you have Section 10, which is concerned directly to give effect to Brussels Convention, as opposed to a more generalised version of the restrictive theory. And of course, customary international law then comes in at the last stage when you're considering whether Section 10.4a is inconsistent with Article 6 ECHR, and therefore Section 3 of the Human Rights Act is engaged.
We have here a statute which is intended to give effect to the Brussels Convention.
My Lord, yes.
And which is intended to give effect to the European Convention on State Immunity.
It is not, no. Oh, sorry, the statute is, I'm sorry.
No, the statute is intended to give effect to two international conventions.
Correct, my Lord, yes.
The Brussels Convention and the European Convention on State Immunity.
My Lord, yes.
Now, what bearing does that have on the relevance of developing rules of customary international law in relation to the same subject matter?
Well, it does mean that the developing rules of customary international law have to be approached in a very different way to the usual case, because there is direct influence of the Brussels Convention. That's what the drafter is seeking to give effect to. At the most,
It wouldn't be possible to say there was a custom in international law that was inconsistent with the convention, would it?
no,
I mean, I don't see how you would derive such a custom.
my lord, that is possible. That would only come in at the third stage of the argument, though. That would only come in at the Section 3 HRA stage. It wouldn't come in before.
Would that arise? Because, of course, the Brussels Convention is in 1926, and it's conceivable, I'm not suggesting it is the case here, that customary international law would have developed, or changed, if you like, from what it was in 1926.
Well, that is rather Argentum's case.
That's their case.
But it's still enforced, the convention. Nobody said we're not abiding by it anymore.
That is
So I don't really see how you would infer the custom that was contrary to it.
Well, my lord,
Unless states were disobeying the convention and treating that themselves as bound by something other than it. The ones that are party to it, but that's quite a lot of states.
yes, my lord, the custom could develop in a different way. So the custom could develop in a way that Argentum says, which is that you don't focus on purpose at all, see primo congresso, although in fact it doesn't say that. You only focus on whether there are commercial transactions, and if there are commercial transactions, even if they are not with the state, then that in effect sets the immunity or otherwise. And that would be inconsistent with the Brussels Convention.
But you'd have to show that the vast majority of states were operating that as a state practice and recognising that as binding on them. I think it's very hard to do when you've got an explicit convention that binds them.
My lord,
A lot of them, like Britain.
I
don't know how you're going to find some British state practice that is not consistent with the convention.
My lord, I entirely agree with you, and that's why the relevant English cases, and these are the cases on state-owned ships, they are completely consistent with the Brussels Convention, because what they're doing is they're focusing on the use or intended use of the vessel. The key question in the Philippine Admiral is, how is that vessel being used? Is it being used as a trading vessel or not? And that is the same in all the cases that concern state-owned ships, except the ones like the Porto Alexandra, which back in the 1920s, which are now regarded as being wrongly decided because a principle of absolute immunity was applied. But otherwise, what one sees is a consistent line of cases. And here, Lord Sumption's speech in Benkabush is very helpful, because it starts out tracing through the development of customary international law. The purpose there is to see, is there a rule of customary international law that applies absolute immunity, or is there a restrictive theory within customary international law? And Lord Sumption and their other lordships held the latter. But when one goes through the cases that he refers to, the Schooner Exchange, the Parlement Belge, the Charquier, and the Christina, and that of course is the three separate speeches of Lords Maugham, Thankton, and I forget, and one other, they are saying again and again that immunity is by reference of the nature of the use of the vessel. That culminates in the decision of the Privy Council in the Philippine Admiral. And that is the approach that is to be applied as a matter of English law, but also as a matter of customary international law. Because when one looks at the when one looks at the international law materials, some of which are clearly applying or considering they're applying customary international law, again it is by reference, immunity is by reference to the nature of the use of the vessel, not by reference to how was the vessel acquired, not by reference, for example, to contracts pursuant to which the vessel is being operated, which I think would be the closest analogue to a carriage contract for the carriage of cargo.
Mr. Wordsworth, I think my question was related to a more general issue, which is this. You're seeking to rely on customary international law to support your interpretation of a statute which is giving effect to two international conventions and which in certain respects, which may not be relevant in this case, but which in certain respects enacts rules of immunity which do not coincide with the rules applicable in customary international law.
Yes, my lord. So I do apologise for the long answer. So that customary international law would still play at least two roles, wouldn't it? Because it would play a role in interpreting the Brussels Convention, because you have to take into account other relevant rules of international law applicable between the parties as context in interpreting Article 3.3. So it would play a role there, because I think the English court will approach the interpretation of the Brussels Convention just applying the whole range of rules within Articles 31 and 32. Of course, it does. So it would fit within there, and then, of course, it would fit at the other end on the question of potential application engagement of Section 3 HRA. The question, does it sit in the middle, which, of course, is what one sees, for example, in cases like Alcom or in Lord Sumption's speech in Benkabush, speaking in general terms, saying there is a role for customary international law, because in general terms, the 1978 Act is seeking to give effect to the restrictive theory as a matter of English law. It seems to me there may be some role for it still, because one can see that the drafter, in looking at the Brussels Convention, may also have had in mind more generally application of the restrictive theory in English law. I can't say that for certain, because all we know is that Section 10 was intended to give effect to the Brussels Convention.
Yes, thank you.
My Lord, can I take you perhaps quite quickly now to some of the international law materials, and at page 2106 of the authorities, there's an extract from Fox and Webb.
We're back to the bundle.
Sorry, this is back to the normal authorities. I won't be taking you back to the supplemental authorities bundle.
Yes.
This is looking at sources of the law of state immunity, as you can see from the top of the page, and then under the heading provisions as to certain types of state property, looking at warships and trading vessels. In addition to the 1926 Brussels Convention discussed below, there are a number of multilateral conventions regulating seagoing vessels, preserving immunity for certain state-owned or operated vessels, and moderating its effect in respect of others. 3 categories of state vessels are recognised: warships, and then there's a reference to the relevant provisions of the 1958 conventions and the UN Convention on the Law of the Sea. As a second category, the status of other state-owned or operated vessels exclusively used in government non-commercial service is usually equated to that of warships, as with the immunities retained when passing through the territorial sea, subject to the coastal state's right to give notice to leave and state responsibility. The third category of state ships are other state-operated vessels in commercial service, government ships operated for commercial purposes, which enjoy no immunity, being equated to the position of privately owned merchant vessels. This distinction between the second and third category turns on the nature of the ship's use, not the extent of the state's ownership or possession. So, my Lord, the point here, and I can take you through the other materials as well, but it may be I can just do this by giving you the references. But when one looks at the conventions and one looks at the provisions of the Law of the Sea Convention 1982, the immunities with respect to state-owned ships again and again are applied by reference to the nature of the use of the vessel, and there are no materials to suggest that in identifying the nature of the use, you should look at how, for example, the ship was acquired. Was it acquired pursuant to a commercial contract or not? Of course, in general terms, almost all state-owned ships will be so acquired. Nor do you look, for example, at whether the state-owned vessel is being operated by reference to a commercial contract. So, for example, if you take the case of a Coast Guard vessel, which, for whatever reason, the operation of the Coast Guard vessel has been outsourced to a private company, so it's still fulfilling the functions of a Coast Guard vessel, but it's being operated by some private entity, that would make no difference. What matters is how the vessel is being used. Is it being used for commercial purposes or not? If it's for governmental use, then immunity will attach. My Lord, I'm just wondering if that is a convenient moment.
If that's a convenient moment, we'll resume at 2 o'clock. Thank you very much, Mr. Whitworth.